Good afternoon to all of you. Hello, is it audible? Hello? Okay. Dr. Jyoti Grish. Good afternoon. Now, I am pleased to interact with the brilliant student of Remote School of Law. You want to become judicial officers. One thing you must remember that it is the continuous effort of a particular candidate which will make him successful judicial officers. Now, what you are required to do, this examination consists of 3 parts. First part, preliminary examination. Second, main examination. Third is the viva voce. The purpose of interview is to judge the ability of the candidate, whether he can withstand the pressure which is mounted on the judicial officer by different quarters. He is not to succumb to any pressure. He is to be firm and dispassionate, impartial all the way. Now, you are from different part of the country. Some are from Jammu and Kashmir, some from Haryana, some from Punjab, Delhi, Bihar, etc. If you check out the syllabus of various states which conduct the judicial examination, the basic framework is the same. Main subject, for example, you have Code of Civil Procedure, CPC, Evidence Act, Contract Act, Sales of Goods Act. Then you have IPC, CRPC, other laws. There is minor variation with regard to the local laws. Maybe Rajasthan, maybe Himachal Pradesh. So far as Punjab and Haryana are concerned, the syllabus is almost the same. And there are 3 papers. In preliminary paper, you have the whole syllabus and plus general knowledge. General knowledge is on the legal topics. General knowledge is on the current affairs and legal topics. And in order to articulate yourself in general knowledge, you should preferably for half an hour either read the newspaper or listen to English news. Now, there are in preliminary examination, there may be 125 questions or 200 questions. In Delhi, there are 200 questions. In Punjab, Haryana, there are 125 questions. Each question carries 4 marks and 25% is a deduction if your answer is wrong. That way. How you have to prepare for that? Now, do not say that you focus on one important topic that is your favorite. Give equal time. You must give equal time to all the subjects. Now, there are 3 papers of law. In main examination, there will be 3 papers of law. First, Civil Law 1. Civil Law 1 contains Code of Civil Procedure, Contract Act, Evidence Act. Then it has Sales of Goods Act, Transfer of Property Act, Specific Relief Act, etc. etc. Then in Civil Law 2, you have Family Law, Hindu Law, Muslim Law, Customary Law, Registration, and Limitation Act. In third paper, which is titled as Criminal Law, you have Indian Penal Code. Now there is a new name, Bharatiya Nyaya Sanhita. Then you have Code of Criminal Procedure, the new name, which is yet to be enforced. That has not been enforced. Old code remains enforced. That is Indian Penal Code, Code of Criminal Procedure, and the Indian Evidence Act, Bharatiya Sakshi Sanhita. That is, this time there was a question recently on 17th of probably January, 30th of December or January, that what is the new name of the act which deals with the evidence, and that is Bharatiya Sakshi Sanhita 2023. You are only to remember the name, and they are not enforced. They are not the part of your syllabus as yet, but there is no change. If you look at first the Code of Criminal Procedure, there is only 5% change, not more than 5% change in the Code of Criminal Procedure. Mainly, in Indian Evidence Act, 99% is the old act. There are some changes in the Indian Penal Code, but they have changed the section, nothing else, and they have added organized crime, terrorism, etc. etc. What they have done that introduction of information technology, this was already done in 2009. If you look at the amendment of the Code of Criminal Procedure, therefore, do not be scared. Don't have any confusion about the old law and the new law. There is nothing. Old wine and new bottle. Some changes. Those changes. For example, you have this remand period for 15 days, and now police remand maximum 15 days. It could only be during the first 15 days. Now they say it could be during 40 days. Then recording of FIR, digital, etc. etc. There is no much change. Now we come to the proper subject. There is a preliminary examination. What is required in preliminary examination? You should have read Bare Act carefully, all the Bare Acts. You take up the question papers of Punjab, take up the question papers of Jammu and Kashmir, take up the question paper of Himachal Pradesh, Delhi Judicial Service, Bihar Judicial Service, Rajasthan Judicial Service, Madhya Pradesh Judicial Services, means Hindi speaking states, and there you will find pattern is the same. Questions are repeated from this to that. Basic framework remains the same, and you should give equal time. For example, Knowledge of Constitution is very important. Constitution is the basic framework. And what is the basic of our criminal law? That is Article 21, Article 21, Article 20, 22. They are the basic structure of our criminal law, that no procedure shall be unjust. It should be fair, it should be just, it should be reasonable. Everything revolves around this thing. That is why now regarding law of bail, you find different changes. Now study Constitution thoroughly. And when you study one topic, for example, judiciary, there is a question that who was the first Chief Justice of the Supreme Court of British India? And there were 3 questions in one examination on Chief Justice. He was Sir Impey. Then who was the first Chief Justice of Indian Supreme Court? H.R. Kania. And is the present Chief Justice of India is a 48th, 49th or 50th? When you remember one thing, you should try to imagine all the questions, think about all the questions which could be put with regard to that subject. Therefore, you should have a clarity of the concept. Now, give equal time. For example, if CPC is a big act, limitation is small act, but do not think that no question is on limitation. The present practice, the present trend is to discourage the students from cramming, from mugging. They discourage reading from the guides, because when you have studied any question from the guide and answer is given, if there is a little bit change in the language of the question is different in the guide, question is different in the examination. Therefore, you will put the answer which is given in the guide, but that is not the proper answer. Therefore, this would be very clear if you read the Bail Act thoroughly. Therefore, how you are to study, but do not leave. There are some important topics. You give more attention to important topics, but do not leave unattended. Do not miss unimportant, insignificant topics. You must also study, have a thorough reading. Give equal time to all the people that will provide you. Now read from the Bail Act. There is no need to go for the commentary, because time is not in your favor. Time is not in your favor. You have a less time because there are so many Bail Acts and syllabus is very vast. Therefore, you should only have a basic understanding. All the questions, you show me any question which is not on the from the Bail Act. The question will be from the Bail Act or in the preliminary examination. From the Bail Act or the leading case law. Leading case law which you study in the class. For example, like FIR, you have Lalita Kumari versus Government of UP Constitutional Bench decision. Similarly, you have Hardeep Singh versus State of Punjab Constitutional Bench decision, on which many questions are put. That, for example, FIR is lodged. FIR is lodged. 3 persons are named in the FIR, but when IO, investigation officer, collects the evidence, he finds that someone else is there, then magistrate is not bound to accept the version of police. He can add that person in the category accused. If he does not add, then when evidence would be recorded at the time of trial, and the witness deposes that that person is also the accused, the court has the power to call him. This is what Hardeep Singh Constitution Bench say that court has the power. Then the question would be that there are 3 types of examination. If you study the law of evidence, examination chief, cross-examination, re-examination, can that person be called as accused simply on the basis of the statement recorded in examination chief, or let cross-examination be over? There was a difference of opinion among the various judgments of Supreme Court, which was resolved by the Supreme Court in the Hardeep Singh v. State of Punjab. Similarly, regarding anticipatory bail, then constitutionality of death penalty, there are questions which are recently put in the daily judicial examination. Therefore, read leading judgments and for example, how much time you have to study? At least 10 hours. If you are a student, you can reduce the time. But when you have completed your law, at least 10 to 12 hours study is required, and give equal time to all the barracks and read them thoroughly. If you do not understand anything from the barrack, then you read good textbook, and do not read whole of the chapter. Read only that part on which you are unable to understand, which you do not understand. There is no clarity in your mind in that. Therefore, you read only that part. If after reading that, you are not in a position to comprehend, to understand it properly, then what you are required to do, you approach your teacher and put a specific question to the teacher, and do not insist that teacher should give you the answer there and then. Let the teacher apply his mind. Let the teacher apply his mind. And if teacher is not aware about that, he will search for you. Then that is the proper way. And the purpose of attending any institute is that institute articulates the method of your study. It regulates your study. It provides inputs to your studies. And when you interact with the fellow students in the academy, you, by interaction, learn more, because no one is a born scholar. Therefore, you should put questions to yourself, and you learn from the fellow student and from the teacher also. Then this is one aspect. So there are 3 papers: civil law 1, civil law 2, criminal law. Then there are 2 other papers. Language paper. English is common. Whether you are in Jammu and Kashmir, you are in Himachal Pradesh, you are in Haryana or Punjab. This is the language. And essay carries almost 100 marks. Generally, the question paper of English is on 200 marks. And 50 marks are from grammar. If you check up the merit list of any judicial examination, maybe of Delhi, maybe of Punjab, maybe of Haryana, maybe of Madhya Pradesh, Jammu Kashmir, the people, the marks in law papers are not, there is no much variation, difference in the law papers. But so far as language is concerned, there is a lot of variation because in 50 marks of grammar, you can attain 50, you can at least attain 40 marks, which is not possible in the law paper. Therefore, do not ignore the language. And if your English is good, if your language is good, you have a command over the language. That way, that would be a plus point for the examiner who will examine your civil law 1, civil law 2, or criminal law paper, because it is the language which is the indicator of the intellectual level of the candidate, that he is a brilliant. Certainly, you are likely, I can tell you from my experience, you are likely to get 5% more marks if your language is good, if your writing is good. In that way, handwriting also makes a lot of difference, because what is happening at present, you know, there are so many candidates. When you take preliminary examination, in that case, if the number of the post is 40, then only 410 times 400% would be selected out of the whole list. Top 400 will be selected for the main examination. When 400 take the main examination, in that way 120 would be picked up 3 times for the interview, and out of that 1/3 would be selected. Therefore, we have to be very cautious that you are to prepare thoroughly. Do not leave this or that. One other important aspect, which is very important so far as these judicial examinations are concerned, that time management is the most important. Time management is the most important. If now there are 2 hours for the preliminary examination and 125 questions or 200 questions, in that way, do not stuck up at the first question. Now, one question you may attempt in 10 seconds. You can attempt question in 10 seconds. If the question which you know 100%, that should be your first preference. Go on, read the question paper quickly, understand and mark. If you know it thoroughly, mark it. If you do not know it thoroughly, leave it. Then go to the next question. The question which you know 100%, that should be your first preference. The question which you know 90%, 75%, second, and so on. If you are not sure, then you can leave the questions, but do not waste your time that I will, if this is the first question, I must attempt this, thereafter I will go to the next. That is not the proper approach when you try to study the case. Therefore, language papers are equally important. These are equally important. And read good books. Some now cheap books appear. 50% language is wrong. Other, they do not give. For example, there is one book by Mishra, Indian Penal Code by Mishra. Many students study that book and they also study CRPC by Mishra, very popular for the students. But they have not mentioned the case of Lalita Kumari, which was decided in 2014, a constitutional bench decision, historic case, on which many questions are put in the preliminary as well as in the main examination of judiciary, maybe in Rajasthan, maybe in Punjab, maybe in Haryana, or maybe Delhi. This time, there was also a question in the Delhi Judiciary Commission on Lalita Kumari. Therefore, read good book, and if there is some latest case law, add that to your vocabulary. That would be the proper approach how you are to prepare for that. Give equal time. Therefore, and one other aspect is there. These examinations are not very difficult. Judicial service at present is even better than the IAS. If you look at the benefits which are given to the judicial officers, they are more benefits than to the IAS officers. There is a political pressure in case of IAS officers, but there is no pressure, government, etc., for the judicial officers. They are not subordinate to the state executive. One day you are DC, other day you are made in charge of computer or made in charge of rules, etc., and the secretariat like a clerk. That is not the case in case of judiciary. You have to decide the cases. You have to command. You are not to appear before anyone. If you do work honestly, there are so many benefits. The starting, if you get 1,25,000, then the other benefits may be more than 2 lakh. That is the now parallel practice so far as judiciary, because they say that judicial officers should be honorably means financially made sustainable so that they do not look to any other option like corruption, etc., etc. So corruption may be there, but they have tried their level best to reduce to that. Therefore, this examination is now the best examination. You should prepare for it, and I have about 53-year experience, more than that, and right from my beginning, I have not seen any person that who has worked hard and he has not been successful. He may not be as successful in this way in one examination. If one is not selected as judicial officer, he can become ADA, he can become law officer. Now there are various law firms, private as well as government, where they recruit legal officers. Law now become a technical subject. Therefore, you can go to a bank, law officer in a bank. There are law officers in the bank. Therefore, there are wide avenues for this. But this you can only get if you have a proper coaching or proper mechanism is provided to you for the study where you feel free to study without any stress on your mind, and the environment is such that you get encouraged. Therefore, if you are not successful in one examination, that should not be a discouragement to you. If you, I think, all of you, I think you know Napoleon, the great French general, and there is a saying by Napoleon that my strength lies in my defeat. My strength, one asked him, he said, my strength lies in my defeat. Why? That if I win, then I will become lazy. I will not make efforts. But if I am defeated, I will re-energize, re-strengthen myself, make more efforts, and then I will become successful. Therefore, failures are the pillars to success. Don't be discouraged that you cannot do this, I cannot do this. Everything is possible. If son of a peon who is just studying on a studying while working, he is studying and he can become, you have all the pleasure at your time, all the comforts. Why can't you work hard? Why can't you come to that level? Therefore, do not be discouraged that you have not been able to clear one examination. I have seen people clearing other examinations. If you do not clear 5 times or in the fifth attempt, side by side, you have started practice. When you start practice, you say that I spent 5 years in academy. I have not been successful. I have not. But after 7 years of your practice, you are eligible for examination of additional district and session judge ADJ. And I have seen many persons who could not make it, who could not qualify PCA judicial officer examination, but they were successful in the ADJ examination, additional district and session judge examination. There is a direct recruitment to them, and a judicial officer who was selected in the first attempt. If he is selected in the first attempt and other person was unsuccessful for the last 5 years, and after 7 years he appears and he becomes ADA. This judicial officer who was selected in the first attempt would become ADA after 12 years, and he has become ADA after 7 years. That makes a lot of difference. Then, as advocate, when you have knowledge, people will come to you. They will knowledge will pay you. Latest case law will pay you. The study will pay you. Now, commercial courts, negotiable instrument act, new field avenues are being available. Special courts are being very check bounces. How it is to be disposed, the case is to be disposed of. The new commercial courts are being applied. We are in the days of materialism. Therefore, don't be discouraged. Study, and in your institution, you have a good library. You have good teachers who can guide you properly, and you will have to goad the teacher. You will have to make the teacher to study. It depends upon you how you can make the teacher to study, because if you put more question should be sensible, question should be relevant, not to harass the teacher, but to make the teacher to work hard. You can make me work hard. I don't mind if you put me so many questions. I will rather welcome it. Good teacher quality is that he should welcome the questions, because teacher would learn from the questions which he could have never conceived or thought of, and student becomes asset to him in that way. Therefore, my advice to you is that give equal time to all the papers. Do not be lethargic that you will study only when examination are announced. You do not leave anything to chance. Study regularly, read newspaper, general knowledge should be your update that way. And if you study thoroughly, you will be confident. And then what is to be done if you feel discouraged? Better have sound sleep. Do not go for the social media, etc. Social media now has become a disease. It is a disease which upsets your mind. Those people who go to IIT or go to for CLAT, etc., they do not go for this mobile system, etc., etc., because there you do not find the truth. Therefore, now Google is available to you. You can search general knowledge from the Google if you are not aware that what is the position of a particular judge of Supreme Court. Our latest now, the one lady judge who was the first judge of the Supreme Court, Fatma Bibi. Fatma Bibi was the first lady judge of Supreme Court. Recently, she was awarded. Such type of question are generally asked. These are the legal questions. They test your knowledge of law, awareness about the legal or the current topics. Therefore, this way you can study. But these are generally the tips. And if you are not convinced about anything, do not insist on that. If anything is not understandable to you, leave it. Other procedure, proper method of approach is that when you study a particular topic and there are some clarifications which are required on that topic, you should have separate registers, because if you have that in the mobile that may be deleted, etc., you must have that is hard copy of that. Prepare, write the question paper, questions which are not clear to you, and chapter wise, because a teacher won't have that much time. Therefore, you prepare all the questions for which you require clarification, then get time from the teacher, and then get clarification and write answer as per the directions of the teacher. That way, prepare that way. You have different registers or copies for IPC, for CRPC, for evidence, for CPC, for contract, for Hindu law, etc., etc., for language. Therefore, in all these cases, you have to be very cautious that you should not waste any time by here and there. Give what should be your schedule. For example, you must sleep for 7 8 hours. You must study for sufficient time. Even then, you will have 4 5 hours for that purpose. That will be sufficient for your healthy way of life. Therefore, study properly and do not waste your time when you are in the remote, because this is a good place where you have a library, you have good teachers like Amrish, who has been a very good student in the university and a good leader, providing good education and guidance to you. Therefore, you should be very lucky to be in the remote and to join some good academy like anything, divine or else, and do the hard work. Hello? Anything, any query? I leave this for, hello? Anything you want to ask? No? Hello? Hello? Anything? Any question which you want to ask? Hello? Jyoti? Hello? Akshay? Hello? Any question? Hello? Any question? Jashandeep, beta, no, you should ask the question. You should ask the question. Now I repeat, beta, read. Now may I ask one question that who was the first Governor General of India? Who was the first Governor General of India? Hello? Who was the first Governor General of India? Hamra. Now, Lord Mountbatten was the first Governor General of India. Then the other question would be, who was the first Governor, who was the first Indian Governor General of India? That was Rajgopalachari. Who was the first Lady Chief Minister? Now, these are the things where you should remember. हाँ सर, हाँ सारू Sharma, beta, it is written that date of new CRPC will be notified, and something which you will remember, beta, actually these acts are not properly designed, thought of. What amendments have been made, they have not clarified anything. Now new CRPC will come into effect when notification for its enforcement will be issued. When notification for its enforcement will be issued, notification is to be issued by the Government of India. Now they are thinking of digitalization of the judiciary, but they say that FIR can be recorded. But if you read the section 173, etc., it deals with new CRPC, Bhartiya Nagarik Shiksha Sanhita, that it can be by email. But in email, as you see, section 154 of CRPC and the section section 173, the FIR section is 154. Beta, very good. Hitakshi Sharma, beta, you have put a very excellent question. Now they have enacted the law. So far as you are concerned, as you know that beta, you have studied Article 20 of the Constitution. Article 20 question retrospective operation of penal law. Penal law have no retrospective operation. These are penal laws. They have no retrospective operation. They will come into effect from the date. But for that, they have not created any infrastructure. When you are to write FIR through email, then this section also says, look here, every information relating to the commission of common offence, in respect to the area where the offence is committed, may be given orally or by electronic communication to an officer in charge of police station. If orally, it shall be reduced to writing. By electronic means, shall be taken record by him on being signed within 3 days. बड़ा 3 दिन के बाद आएगा. Hello, you will sign the FIR within 3 days. But when you study present section 157 of CRPC, the very purpose of recording FIR is that criminal law machinery is put in action. Criminal law machinery is put in action immediately so that the accused is not in a position to run away, to destroy the evidence, because whole thing in criminal cases depends upon the evidence. If there is no evidence, person cannot be convicted. Therefore, the whole purpose will be defeated. The police will start investigation after 3 days. They have left so many lacuna, defect in this system. Therefore, because these amending laws will affect aspiring studies, because whenever we thought to start this question creates so much pressure that what it tomorrow the syllabus change according to the then what will happen? Because nothing will happen. Nothing will happen. Because nothing will happen. The teacher who teaches you, I have already told you, then 95% of CRPC is the same. What they have done, they have made, instead of 484, they have made 531 sections. But what has happened? There are some like plea bargaining. Chapter 21 is CRPC. It is 265A, B, C, D, etc. Now A has been made separate section, B has been made section. Similarly, section 105 onwards, they have been made separate section. Nothing has changed except very that they have given the definition of electronic communication, etc., etc. Nothing has changed. And now I may draw your attention. बेटा देखो, वो कहते हैं ना, बेटा if there is an offence which is punishable with more than 7 years, more than, in that case, forensic evidence would be there. बेटा सेक्शन 157 है ना, प्रेजेंट है, वो है सेक्शन 176. नो चेंज. देखो procedure for investigation. When information as to the commission of any such offence is given against any person by name, well, 176 of Partiya Nagar Seksha Sansa is same as section 157 of CRPC. देखो इसका जो है सब सेक्शन 3 on the receipt of having information relating to the commission of an offence which is made punishable for 7 years or more, the officer in charge of the police station shall, from such date as may be notified, within a period of 5 years, by the state government in this regard cause the forensic expert to visit the field. बेटा अब अभी तो ये लागू नहीं हुई, इट हैज नॉट बीन विद इन ए पीरियड ऑफ 5 years तो फोरेंसिक को बुलाएगा. बेटा देयर आर मेनी lacunas, there are many problems which these laws have created and you should not be worried about this thing. So far as your present syllabus is concerned, if now recently Haryana has advertised, I think more than 155 posts or 170. Now there what they have mentioned, IPC, CRPC and the law of evidence. These are the laws which they have mentioned. Therefore, don't worry about that. You leave it. That is why I told you in the very beginning that it is old wine in new bottle, not change. Changes, they have created the confusion which is to be removed. That is why P. Chidambaram gave a dissenting note on this. He is a learned Harvard scholar. He gave a dissenting note. Other people also, they have given. There are many things. But you should not bother about that. You should study. And what would be that if you are very anxious to know about this, Takshi, but I will come to your university someday and I will clarify this so far as the changes in CRPC are concerned, that what changes have been made and what is the effect of that. That will be over. Don't worry about this. Hello? Takshi, beta, anything else? Takshi, beta, ask any question. If I don't know, I will read and inform you. But don't worry about this. There is nothing. I have read one thing about you, 5 years, etc. These are the questions which you need not worry about that. You should prepare about the present syllabus. And these laws, they are the same. Not much change. So far changes are concerned, they will be taught to you when the time comes. Or you can ask your teacher, she will be the best person to guide you properly. You have a competent head of the department who is well versed in all these things. But so far as this is concerned, no pressure. Pressure should be divorced. Pressure should be banished. No pressure. Okay? Thoroughly. That is the concept clear. Leading case law, regular study, language. Now latent language. In one, when you study some good book, you will find the basic idea behind that. Now, for example, you study group liability. Group liability. There is no concept of vicarious liability in the criminal law, but criminal cases are decided on the basis of evidence. If one person commits crime, evidence will be there. If 5 persons manhandle a person, beat him, you might be, even now cameras are there, even camera won't be able to locate which injury has been caused by what person. Therefore, the basic principle of administration of criminal justice is no guilty should escape, no innocent should suffer. That is why benefit of doubt shall go to the accused. But what would happen when many persons plan, they share the guilty mind? and in execution, in furtherance, to carry out that guilty mind, the act is committed by one or two of them, then in that case, not only those two who have committed that, but other also who share the guilty mind should be responsible for that. That is why Section 34 of the IPC says when a criminal act is done by several persons in furtherance of the common intention of all, each of such persons shall be liable for that act as if it were done by him alone. As if it were done by him alone. Therefore, the principle of vicarious liability is there as an exception to the general principle of criminal law. There are bases for that. Therefore, these changes which have been made, can be ignored. You should study the basic law, and basic law is the same as the old one. Rather, they should have changed the CPC, which is of 1908, or this Contract Act of 1872. They have come to criminal law. Now, CRPC is of 1973. It has replaced the CRPC of 1898, and it has allowed all the changes. That is why they are not in a position to make much changes in the CRPC, except the introduction of electronic device or giving more powers to the police. Any other question, beta, which you want to ask? Akshay, anything, any question which you want to ask? Hello, Akshay. Beta, when you study one thing, now if they say that what is FIR, the word FIR is not defined in section 154 of the CRPC. Nowhere section 154 says what is FIR, but what information is given under section 154 is known as FIR. Akshay, what is the section, Akshay, in which year you are? Have you studied CRPC? Hello, Akshay? Hello? Section 207 of CRPC says copies of the documents which are to be supplied to the accused. It says first information report recorded under section 154. Therefore, it is section 207 of CRPC from which we come to know that the information which is given to the police first in point of time regarding commission of cognizant offence is known as first information report. Any other question? Any other question which you want to ask? Any query? Anything? Work hard. Wish you all the best. Don't be scared of anything. You will be successful this way or that way. Okay. Thank you.